Artificial intelligence could soon be used in Australian courtrooms instead of a judge's discretion.
Victorian judge has reprimanded a lawyer for using artificial intelligence for his arguments during a murder case involving a teenage boy.
Lawyers or self-represented parties fabricated non-existent cases in courts and got caught up with embarrassment. How many of this kind of news have you heard over the last 12 months? They just keep coming all around the globe. In Coase Allison, the expert used AI to draft expert report and was titled by US District Court in Minnesota as deepfakes. In Luck and Secretary Services Australia, Ms. Luck, who made up cases, was prohibited from starting or conducting any further legal proceedings in the federal court. In the UK case, Allende and London Borough of Haringey, a very junior barrister used a fake case but denied using generative AI was fined for £2,000. It was reported that the legal community had over 80 incidents of AI hallucinations or fabricated citations in July and August alone, and we will only see more of them in the future. Whether you are a legal practitioner or a user of legal services, we are collectively immersed in the unprecedented technological revolution. As artificial intelligence technology matures, the impact of generative AI and large language models on existing regulatory framework has now reached the legal sphere, arguably the most conservative domain. Faced with this surging tide of technological innovation, how will Australian courts navigate this era while upholding procedural fairness and safeguarding the rule of law? Let's have a deep dive on the recent federal court judgment, which involves a case that is different from all others. On 22nd July 2020, an application has been filed with the Federal Court seeking judicial review of a decision of the Administrative Appeals Tribunal, also known as AAT. The applicant was represented in relation to the judicial review by his lawyer. The Minister for Immigration and Multicultural Affairs is the first respondent, and AAT is the second respondent. On 25th October 2024, the lawyer filed an outline of submissions. The applicant submitted a list of 17 cases from 1993 to 2018 which alleged to support the application. If you take a close look at the cases' name, they look fairly genuine as they bear the parties' names, year of proceedings, and end up with federal court's unique citations. However, all those cases were made up from nowhere. On 11th November 2024, the minister filed their outline of submissions with the court. And note that those cases did not exist. Yes, you heard that right. All 17 cases cited by the applicant's lawyer were non-existent. On 19th November 2024, the lawyer sent the court an email without copying the other party, trying to file an amended submissions that remove all non-existent cases. In the email, the lawyer attempted to cover his wrongs by saying this: "I'm forwarding herewith an amended submission for the applicant. I acknowledge the errors identified by the respondent regarding the case law citations and purported codes from the tribunal's decisions in my submission. These errors were unintentional, and I deeply regret them. Despite these mistakes, they do not affect the substantive issues raised in the application for judicial review, which reveals significant flaws in the AAT's decision-making process. This attached amended submissions has corrected my original submission." It is apparent that the lawyer's view was that those non-existent cases were cited as an unintentional error. The problem is that there are 17 of them. On 19th November 2024, the court's associate replied to him saying that it was not appropriate for a party to communicate with the court without copying the other party. The lawyer then emailed the court apologizing and stating that the error was unintentional. As a result of this drama, the final hearing had to be vacated, and the parties had a directional hearing on 25th November 2024 instead. During the hearing, the court inquired as to whether the lawyer's submissions had been generated using AI program. The lawyer stated that he had used AI to identify Australian cases, but it provided him with non-existent case law. Embarrassing enough, the lawyer's client also attended over Microsoft Teams under the assistance of an interpreter. The court expressed its concern about the lawyer's conduct and his failure to check the accuracy of what had been filed with the court. The court has also noted that a considerable amount of time has been wasted by checking the citations and attempting to find the purported authorities. Is that all? No. The court made orders which required the lawyer to file and serve an affidavit addressing how the submissions were generated, including a full explanation as to why the submissions contained references to fictional authorities and purported quotations from the tribunal's decisions. The orders also asked the lawyer to file and serve written submissions as to why he should not be referred to the Office of the New South Wales Legal Services Commissioner. Let's pause here for a moment and explain what is Office of New South Wales Legal Services Commissioner, or OLSC, and what it does. It is an independent authority to whom complaints about lawyers in New South Wales can be made. The Legal Services Commissioner has the power to investigate complaints, including those which allege unsatisfactory professional conduct or professional misconduct by a legal practitioner, and has the power to take disciplinary actions against the practitioners, including immediate suspension of license, role removal, fine, reprimand, and non-regulatory sanction. On 2nd December 2024, in compliance with the orders, the applicant lawyer filed an affidavit and written submissions. On 10th December 2024, final hearing for the substantive matter was heard at the Parramatta Registry of the Federal Court. The court eventually made the judgment on 31st January 2025 to dismiss the application for judicial review and granted cost orders in favour of the minister, and which the lawyer's client was required to pay $8,371. After the proceedings in respect of the substantive judicial review, the court invited the lawyer to make submissions as to why he should not be referred to the Legal Services Commissioner. Both the lawyer and the minister made submissions through their counsels. Let's now look at what the parties have argued. The lawyer's points are fairly simple. Firstly, he sincerely apologized for his conduct and stated that it was the product of inadvertence. The lawyer further stated that since he was admitted in 1997, the conduct never previously occurred in his 20 years of practice, and it will never occur again. Secondly, the lawyer explained that due to time constraints and his health issues, he decided to use AI, which had been promoted by reputable legal services such as Leap and LexisNexis as being of existence in legal practices. I'm pretty sure neither Leap nor LexisNexis should be happy after knowing their names were mentioned in the same breath. The lawyer further explained that he accessed the site known as ChatGPT, inserted some words, and the site prepared a summary of cases for him. He said the summary read well, so he incorporated the authorities and references into his submissions without checking the details. As to the health issues, that referred to a spinal surgery that he needed to undertake in the future. The counsel for the lawyer also asked for the court's leniency as the lawyer was approaching the end of his career. Thirdly, the lawyer said the Chief Justice of Supreme Court of New South Wales published a practice notes regarding generative AI on 21st November 2024, which was after his submissions. His logic was that if he had access to such practice note earlier, he would not have used AI-generated information. Wow, that sounds like a blame for the Chief Justice's delay of publishing the practice note. The minister's submissions are that, firstly, the lawyer failed to exercise adequate care in allowing submissions which contain false citation to be filed. Citing fake cases in court historically would result in the lawyer's conduct being referred to the Legal Services Commissioner. Second, such misuse would likely be a matter of increasing concern in the future and must be nipped in the bud. It is public interest in ensuring that the Legal Services Commissioner is aware of this case. So what does the court say? Firstly, the court accepts that the lawyer genuinely regrets his conduct and that such conduct is unlikely to be repeated. The court also accepts that the lawyer took steps to provide amended submissions as soon as becoming aware of non-existent case citations. The court distinguishes the case from the previous case in Dale, in which the solicitor provided a list of fictional authorities and case summaries generated by AI within the Leap practice management software. However, the court considers that a considerable amount of time has been wasted in court and unnecessary additional work has been created for the court and the minister. The court concluded that the conduct falls short of the standard of competence and diligence. The conduct also falls short of a legal practitioner's duty to the court, including the duty to ensure that the court is not deceived or misled, even if unintentionally. Lastly, the court is of the view that there is a strong public interest in referring this conduct to the regulatory authority in New South Wales, given the increase of generative AI tools by legal practitioners. The court stated, the use of generative AI in legal proceedings is a live and evolving issue. Having regarding to all the circumstances, the court has ordered to refer the matter to the Legal Services Commissioner due to the public interest concern. The court accepts the lawyer is deeply embarrassed by his conduct, and it is not the court's intention to embarrass him any further. Therefore, the court subsequently has anonymized the name of the lawyer to protect his identity. The court also indicated that even if the matter would have been referred to the Legal Services Commissioner, the Commissioner in making the assessment would take into account the lawyer's track records, his advancing age, his significant health issues, and the regret as well as his remorse he has expressed for his conduct. These might constitute mitigating factors. Interestingly, the court in the judgment expressed the concern that although the Supreme Court of New South Wales had issued guidelines around the use of generative AI, other courts, including the Federal Court, were yet to develop their guidelines. However, a few months later, on 27 June 2025, the Federal Court published a comprehensive overview on AI use restrictions in different Australian jurisdictions. It is such a great guidelines, and I strongly recommend everyone to read it. For the purpose of this video, I will only set out the most important points. Firstly, the court expects that the legal practitioners will use generative AI to make disclosure. In New South Wales, the court now requires the affidavit, witness statement, or character reference to include a disclosure that generative AI was not used in generating the contents, including exhibits. Secondly, be careful of the information to be fed into large language model. For example, subpoena materials must not be entered into any generative AI program unless such information will remain within the controlled environment of technological platform and is kept confidential. Thirdly, what is permitted use? Well, documents such as chronologies, index, and summaries on transcripts may be okay, but in general, the parties will be responsible for material that is tendered to court, in particular evidence and expert reports. Law firm partners and counsels need to check the citations rather than assume they are accurate. It is notable that it's not the end, as Justice Needham mentioned that the Federal Court has not yet reached a position on how it should regulate or deal with generative AI in proceedings before it, and the court will adopt a watch and learn approach moving forward. As correctly pointed out by the Federal Court, the space is moving so fast that what seems appropriate now may be found to be squelching the best approaches to litigation in the near future. It is expected that the guidelines on AI use for legal proceedings will be reviewed and updated on a regular basis. Do you think court will tend to embrace or limit AI when time goes by? Let me know your thoughts. Also, you may click the link in the comment section below for the full case and the article from the Federal Court. We'll see you next time.